Wessing. Welcome to our webinar today. Today's webinar is the third in our program for 2013. And this is part of our monthly webinar program where we bring you our expertise and views on topical data protection issues. Now, our regular attendees will be very familiar with our previous topics, which have included topics such as cookies, data security, mobile apps and privacy, and we've also looked at other topical or hot topic issues such as data transfers and cloud computing. More recently, we looked at data transfers again, as it was such a topical issue, and these topics and all our other topics that we've covered by webinars are available. If you missed them, still available if you want to engage on those particular topics on our website. Today we're going to be looking at the topic of the proposed EC European Commission Data Protection Regulation. Now, for those of you who are new to Taylor Wessing or new to our webinar program, welcome to you. As you'll see from the slide in front of you, Taylor Wessing is a leading international law firm. We act for a range of leading clients in local and international markets, providing a full-service law firm offering from our office footprint, which spans across Northern, Central and Eastern Europe, and also the Middle East and Asia. More details about that are on the slide that appears in front of you now, and that will be there for your reference. Today's webinar in particular is brought to you by Taylor Wessing's International Data Protection Practice. Now, our team advises on all aspects of data protection and information law, and we do so from our office footprint, as I've just explained to you. Our practice is a global 22-partner-driven team, and it's also complemented by our international network of data privacy law specialists. We're also proud to have recently launched our brand new website. We launched this just before Christmas, and this is specifically for all things data protection. And this is where Taylor Wessing brings everything to do with data protection under one particular banner and in one location. That's our global data hub, as you can see on the slide in front of you. And from this site, you'll be able to access news, weekly updates, which will appear on the site, and also a monthly mail shot is available, bringing you, for example, the topical issues that we look at on a monthly basis. Today, we're looking at one of those particular topical issues, and that is the EC proposed draft regulation. Access to webinars and events forthcoming and also archived are also available from the Global Data Hub. Also, you can access our groundbreaking risk maps. These will give you an at-a-glance view of data protection issues with an interactive feature where you can search by different question sets against different countries. If you haven't had a look at that yet, please do have a look and also give us your feedback on areas that you would like us to cover in the future. As introduced, my name is Banj. I head the UK Data Protection Practice, and I'll be presenting today alongside Sally Anaro, who's a senior member of the data protection team here at Taylor Wessing. Our profiles appear for you on the slide in front and available for your reference. In terms of today's subject, we're going to look at the EC European Commission Draft Data Protection Regulation. And this is the second time we're visiting this subject. We looked at this last year. In fact, it kick-started the webinar program for us in 2012. And we're revisiting this for a number of reasons, which will become clear as I look at the agenda in a moment. There's an awful lot happening around the proposed data protection regulation. And what we're going to look at today is to not only give you a bit of an introduction and an overview into data protection law and what these proposals are all about. We're going to look at the proposal and the different positions that have been adopted with regards to the data protection regulation. It is a draft regulation, and it is going through a variety of different parliamentary and European Commission processes. So a lot is being said, a lot is being reported, some of it with basis and some of it with speculation. And what we're going to try and do is bring to you today some of that which has been reported with some degree of basis. So not really speculating on a lot of the gossip that's been going around, but really focusing on what the different committees and chambers have been reporting in terms of the up-to-date position and what the directive is likely to be doing going forward. So that's what we'll cover in terms of the proposals and the different positions as they stand at the moment. We're also going to take a look at the impacts of the proposed regulation. And we're going to look at that by just applying that in a variety of different contexts. So we thought we'd do that just to try and give you a practical approach in terms of how the regulation may hit home depending on which part of your organisation will be most affected, if indeed it's only linked to one particular part. So we're going to look at not only sector-specific areas but also operational areas. First of all, we'll look at some aspects of the regulation and how that may impact in the area of human resources. We'll take a sector look and just look at some of the key issues in terms of impact for financial services and also life sciences. And we've chosen these because they are data-rich sectors, and therefore we would expect the new regulation to have an impact. And for the same reason, we've chosen human resources, because it is one of those data-rich aspects of many organizations, and therefore you should expect some impact, if not a lot of impact, from the proposed regulation. And then we're going to take a slightly different approach and look at the issues in terms of the impact from the perspective of cloud computing and also OBA, online behavioural advertising. And that's what we propose to cover today, but we'll also be taking some polling questions towards the end. As always, your polling questions are incredibly valuable, as it allows us to give you pretty much instant feedback on what other attendees are thinking. It's aggregated feedback, so your individual votes, as it were, are not associated to you when we provide this feedback, and it allows you to understand what the general population of attendees for today's webinar are thinking in respect of those questions. We do also plan to bring back the polling questions from previous webinars and report those to you at some stage this year to you as well. There's a wealth of information that we've gathered which I think many organisations would find quite useful in terms of the thinking around those particular issues and polling questions that the attendees provide to us. So very valuable. Please do partake in that. And also, as you think of questions as we go through the event today, please do fire those questions through. Time permitting, we will get to those questions. If we don't, as we always do, we will follow up with you individually and get back to you and give you our views direct on any specific questions that you may pose today that we don't get time to answer. So, let's take a look at the subject in terms of just an introduction to data protection. Just looking at this for a moment, if you are new to data protection is from a European perspective, all stems from the 1995 EC Data Protection Directive. And it's this directive that has been implemented by 27 member states across Europe. So there is no such thing as one EU data protection law. At the moment we have a patchwork of 27 different data protection laws that all seek to implement the minimum standards set out in the 1995 directive. As an example, in the UK we have the Data Protection Act 1998, that brings you that. As with any other piece of legislation, you will find that there are penalties or there are sanctions for getting things wrong, whether that's deliberate or inadvertent, with something that's weighed up under the local applicable data protection law. Some of those penalties, it will not surprise you, are financial penalties. Others are by way of other types of enforcement action or undertaking. That is assessed, as again, by way of example, if you look to the right-hand side of your screen, the 8 data protection principles, the framework under which the UK data protection law implements the 1995 directive. And it's through that framework and the localised legislation that you will then have to comply and address how your organisation deals with key concepts and terms such as personal data, sensitive personal data, which is a species of personal data, and also how you deal with the concepts of processing and determine the roles of data controller and data processor. Quite important to make those determinations because different obligations flow some by law, some by contract, depending on which role you're undertaking for a particular data processing activity. And this is really part of a whole package of data protection or information law and governance structure that we see across Europe at the moment. The data protection laws are supplemented by laws around e-privacy. For example, data in the electronic and the communication sector, data that is used in the context of marketing and online data usage. We also have laws such as the Regulation of Investigatory Powers Act, REPA, which governs the way in which communications can be intercepted and when they can't be intercepted, and the framework of penalties and criminal sanctions that apply in that particular environment. Then you have another layer which builds on top of that, which is essentially by way of guidance and by way of European Commission and working party documentation, such as rules and guidance around encryption and the use of, for example, RFID or radio frequency identification tags, and what is the expectation for data controllers if you are in any one of those particular spaces. So that's just a brief introduction to data protection. And this is a framework that's been around for some time now. It's been around since, in the UK, since 1998, which fully came into force in the year 2000, and then transitioned a few years after that. And we saw a similar timetable for transition around that time across mainland Europe. So we are talking about a law that, from a European directive perspective, came out in 1995, and therefore it was being designed and put together from really the late 80s and the early 90s. And here we are several decades later, asking ourselves the question as to whether or not this framework, this package of data protection law is still fit for purpose. And that's really the exercise that the European Commission has embarked upon over the last few years, testing and questioning whether this framework is fit for purpose, particularly in the world of data and commerce that we have today, which is very different to that existed when the 1995 directive came into force. Today we have an outsourced, digitized, offshored world of commerce which just did not exist at the time. And so as a result of that, we have a new proposed framework that's been issued. Now these proposals for the draft framework were published officially in January 2012. The key difference is that this was published as a regulation and not a data protection directive. And the million-dollar question at the moment is, when is this likely to come into force? And as you'll see from some of the explanation I'm going to give you in the forthcoming slides, there is still a lot to be ironed out before we can have a finalized regulation that is going to be anywhere near something that is acceptable to all the parties and all the different stakeholders. But there is an expectation that we are likely to see something in terms of a finalized regulation, perhaps in 2014. Whatever that is, in terms of the form it takes, is likely to come with a 2-year implementation period, so a sunrise period of 2 years. So we're looking at a period of 2014 to 2016 in terms of when this will begin to really bite on organizations. Just staying at a fairly high level, what does this actually mean, this new regulation? What's it trying to do? Is it an evolution or is it a revolution in terms of what it actually brings? And I think it's actually a bit of both. It's, on one hand, it's an upgrade on the current framework of data protection. We see the same principles being transposed into the proposed framework, the proposed regulation. Definitions of personal data, sensitive personal data, data controller, data processor, and so on and so forth, are also covered in the new regulation. However, they're upgraded, they're upscaled, and they mean more, and in many cases they're tougher to comply with and to meet. There are some concepts that are entirely new that you will not find in the current package, and we'll look at some of those in a moment. And what you'll also see, and we'll hear from the forthcoming slides, that this current proposal as we have it is by no means the final picture. There is still a lot of ambiguity that exists in the current draft. There is still provision for some 40 or so delegated acts, in other words, holes for the European Commission to fill at any time if they wish to do so in the future. There is also a big question mark as to whether or not the regulation, which will apply with direct effect and will not need localized implementing law, whether or not it will genuinely harmonize data protection law across Europe, or whether each individual country will still overlay their own nuances, their own local customs, their own local positions around the protection of information and the rights of data citizens. So still quite a lot to be determined in that regard. There are some key fundamental aspects which I think I'll just explore on the current slide, and we'll delve into these in a bit more detail. What I would say is we're not going to cover all of this in detailed ground today. If you want to flip back to a more broad and in-depth coverage of all the different aspects of the framework, then our webinar on this same subject from last year will give you that. So please do tune into that. It's available in our events archive on the Global Data Hub. Today I just want to highlight what some of those positions are, and then we'll look at some of the current positions on that. So one of the key areas that will change in the current framework is the jurisdictional reach. There is always a debate as to how far the current regulation applies when there is, for example, processing or control that is exerted from outside the European Economic Area, and whether or not the Data Protection Act, the legislation that we currently have, actually extends to reach those organizations that are responsible for the collection of data from data subjects within Europe. Nevertheless, they fall outside of the current definitions of establishment within the jurisdiction and perhaps even the use of processing equipment in the jurisdiction. And this is something that is clearly made possible by advancements in technology that certainly weren't around back in 1995. And to take into account of such technological advancements, in particular web-enabled products and services, the new regulation proposes to provide for that extraterritorial reach. So it is meant to reach out and capture those organizations that are based outside of Europe, whether you're in Asia, whether you're in North America, South America. If you are offering goods or services to data subjects in Europe, or if you're monitoring or otherwise profiling data subjects' behavior, and those data subjects are in Europe, the fact that you have no establishment within Europe will not exclude the extraterritorial reach that is meant to apply from the new regulation. There are also some new concepts which currently do not exist, many of which are actually quite welcomed. So the concept of a home authority is incredibly welcomed. Currently, as I mentioned, you have this patchwork of 27 different member state-based local applicable laws. And if you're operating across all 27 different member states and you are perceived to have or determined to have a data controller entity in each of those member states, then you have a local liability or a local data protection law to observe. And also potentially 27 different regulatory relationships to manage. Under the home authority principle that's been proposed into the regulation, that is likely to be simplified. So there are rules set afoot that if you are established in the main in one particular jurisdiction across Europe, then you can provide for one point of home authority regulatory liaison with that one country's data protection authority, that national regulatory authority. That, I think, is going to be something that's welcomed for many multinational companies that are multi-sited across Europe. We're also going to see new and increased rights coming in. There is the right to be forgotten, the ability for a data subject to turn around to an organization and request that their data is deleted, their digital footprint is erased. This is something that does not exist at the moment. There are rights in relation to objecting to processing that might fall outside of the parameters of what is expected, but a right to be forgotten, and the ability to reach for a digital eraser is something that organisations do not have to deal with right now, and that is going to cause some work to be put into place by many organisations to actually implement that. And the same for concepts such as data portability. The idea that you can move your data and have access to electronic forms of your data, so you can port that data from one controller to another. Again, something that will require technological change. So these are just examples of some of the new rights or expanded rights or enhanced evolutionary rights, such as the right to object and subject access rights, which exist at the moment but will be greatly enhanced, strengthened and toughened under the new proposed framework. Another key aspect is also looking at compliance and responsibilities. And from this perspective, there's quite a lot that is being proposed under the new regulation that puts compliance right on the front foot. It's a frontline obligation to deal with how you comply with data protection, being able to demonstrate that you comply with data protection and the new proposed regulation, and having controls, procedures, verification, measurements to demonstrate that you can comply. And this is now built into the regulation, and this is new. Currently, the data protection framework does not tell you how you go about compliance. We've seen some of these concepts, such as data protection by design, impact assessment, that have been built upon and expanded over recent years. These are now embedded into the new regulation, as is the requirement for a data protection officer. If you are an organisation of a certain size, if you are not a small organisation, you're not an SME, then you will have a requirement to also appoint a data protection officer. And there is a whole procedure set that builds around that. And the data protection officer will have particular roles, will have requirements around documentation to make that documentation available, and also to implement specific tools of compliance, much of which we've outlined on the slide for you there. And this is a fundamental difference between current law and new proposed law. But why should you take this all seriously? Again, because the sting in the tail, as I referred to as penalties earlier on, is going to be more than a mere sting under the new proposed regulation. There will be rights for civil action similar to those that we have at the moment, but more importantly, if you look at the nature of the regulatory fines that may appear under the new regulation, it is a huge sea change compared to what we have at the moment. Fines that will be based on a percentage of global annual turnover, depending on the type of breach or transgression under the new regulation. And we've listed out for you on the current slide how some of those transgressions will fit into one of the 3 tiers of fining system that is built into the new regulation. And for large organisations, you will find that if you take your turnover figure and multiply by 2%, that is a very significant figure that begins to appear on your calculator. Many organisations have said actually it's tens, if not hundreds of millions of pounds for the largest of organisations. So very frightening numbers, and much work will have to be done by many organisations to really fall in line with what the regulation is going to bring for us. I just spent a few moments looking at what the current progress is on the proposals and positions that we have at the moment. And there's been a variety of different organisations, industry groups that have been involved in lobbying, and as I say, lobbying, and more lobbying. There's been an awful lot of that going on by individual groups, industry groups, and so on and so forth. And if we just step back and look at some of the key areas and that have been put forward by some of the organisations, it's interesting to see how some of these positions may or may not change. And, for example, the Article 29 Working Party has had a lot to say in this regard, and I'll look at that in a moment. The UK's Ministry of Justice issued a fairly detailed paper on this last year, and we can provide you with our own summary of that. If that is something you want, please do email and reach out to us, and we can provide you with that summary. But let's just take a look at some of these positions. For example, the UK Information Commissioner's Office has issued its own concerns across a variety of different areas. Let's just look at a couple of these. The ICO, the UK's Information Commissioner's Office, has raised concerns around the prescriptive nature of the regulation and said that the regulation it would prefer should focus on an outcome-based approach and not one that's built on processes and prescriptive ways of achieving data protection compliance going forward. The ICO has also commented that the drafting needs clarification, particularly with regard to the definitions of, for example, personal data and other terms such as pseudonymized data, and we're going to touch on that a little bit later. The ICO said that the right to be forgotten may lead to individuals expecting a degree of protection which, in reality, in practice, probably can't be delivered by many organisations. So have we got the expectation set right here in terms of what's actually achievable by organisations? On the other hand, the ICO supports the concept of a high level of consent that needs to be required, but the ICO does temper this and say there should be calls for a coherent set of alternatives to consent, and consent should not be seen as the be-all and end-all as far as legitimised processing is concerned. The ICO has also said that while EU citizens should have the same rights and data controllers should be subject to the same responsibilities, the ICO does not believe that this requires all the details of the law to be harmonised in exactly the same way. There should be, the ICO's perspective, room to accommodate local legal traditions and those local applicable positions that are quite important to individual member states. The ICO has also said that it does not believe that fines should always be linked to annual turnover, and this has been called for by many individual organisations. And ICO also says that in many cases fines themselves are not always the solution, and there needs to be more built into this that actually allows for other types of enforcement action to be levied or to be there to encourage greater compliance if there should be any breach incident. The ICO has also said there are too much scope for implementing delegated acts. So quite a lot of commentary has been put forward by the ICO. There's a variety of other committees, certainly from the European Parliament, and let's just focus on a couple of those over the next couple of minutes to again give you an idea of what sort of positioning has been adopted across Europe. Not all of the ICO's concerns were picked up by some of these committees, and the first committee I just wanted to comment on is the MEP, the Member of European Parliament Committee for Civil Liberties, Justice and Home Affairs, the LIBE Committee, which issued a draft report on the EC draft data protection package. And this draft report raised several recommendations, some of which included that there should be a substantial reduction in the number of permitted, implementing and delegated acts. I talked about the 40 or so positions that have been reserved for the Commission to implement acts in the future, and the LIBE Committee is saying this really needs to be reduced quite drastically, so now is the time for a debate on what the Commission proposes as opposed to allowing a drip feed change should the Commission wish to impose further changes along the way in the future. The LIBE report also comments on the requiring data processors and the fact that they should be able to rely on legitimate interests in some cases, but in many cases this should be only based if there are extraordinary circumstances. So really calling for a tightening of when legitimate interest as a ground can really be relied upon. There is also commentary around the introduction of the concept of pseudonymous data in respect of the requirements for actually achieving that, and the fact that it should be permissible to use pseudonymized data, and there should perhaps be a call for relaxing some of the rule sets around that. A LIBE Committee has also called for an enhanced definition of data subject, and perhaps not one that's so widely encompassing as the one that is being proposed under the current draft. The LIBE Committee also commented on an increase in the period in which data controllers need to notify on data breaches. At the moment, the regulation refers to 24 hours. So if you have a breach incident within 24 hours of becoming aware of that breach incident, you need to have reported it and reported it to the regulator if certain reporting scenarios have been triggered. And that is a huge change for many organizations in to be able to achieve that level of compliance requirement. And that's been recognized by the LEAD report, which suggests it should be increased to 72 hours. The report also looks at the requirement for data controllers and processors to indemnify individuals for any damage suffered as a result of data breaches that are caused by the transferring of personal data to non-approved countries. So the LEAD report is actually looking towards a greater restriction on the movement of data outside of Europe and greater restriction on international transfers. That's one topic which actually horrifies me, because the whole topic of data transfers is complex enough to achieve for many organizations. So any suggestion that it needs to be tightened, I think, and many of our clients have been suggesting, just would be beyond the realms of perhaps what is really acceptable. There are other positions that have also been put forward by many other committees, such as the Industry, Research and Energy. There is also the Employment and Social Affairs, which has also provided some commentary on this area. And that's really focused on Article 82, which covers processing in the context of the employment environment, and identified a few areas in particular where it believes that there is a requirement to provide for a more comprehensive framework for the protection of employee data in particular, such as special protection for data protection officers, so they can make objective decisions about employee data, given that the employment department of many organizations is so data rich, is so compliance heavy, that the data protection officers ought to have a bit more freedom to allow for the compliance regime to be instituted in the way that it should be throughout a particular organisation. The other area that I wanted to look at today is just to comment for a moment on the Article 29 Working Party, which has also published further comments on the EC draft. And it's focused in particular on 6 policy areas. And on the whole, the position that's been put forward by the Article 29 Working Party defends the approach taken by the regulation, but it does raise concern in certain areas. For example, if you were to look at pseudonymization and encryption, the Working Party has said that, and it has said repeatedly that it regards pseudonymization and encrypted data which traces or indirectly identifies individuals, whether that's alone or in conjunction with other data, should be defined, should be seen as being personal data. It should not escape the ambit of personal data. It also stresses that consent is something that should be tightened up under the regulation. The Article 29 Working Committee is very much against the concept of watering down any particular requirements around consent. As far as governance is concerned, the Working Party is concerned and has expressed its views around additional burdens placed on national regulatory authorities, local data protection supervisory authorities, and whether or not they actually are adequately geared up to deal with the upscaling that will appear through the new regulation, whether they are adequately funded to deal with this. And if you wanted to have a look on our Global Data Hub for this month, you will see that we've got more details set out there around all these different committees that I've just mentioned to you, and in a bit more detail about the different positions taken by these organizations. So you can see from what I've just mentioned that there is still many areas that are there to be defined, many of the areas that are there to be completely agreed upon. But whichever way you look at it, it appears that this regulation is going to go through one way or another. There seems to be enough impetus to drive this forward. And many organizations are saying to us, give us a clue as to how this is likely to impact. How is this really going to impact on our particular organizations? So, from that perspective, let's just take a look at a few areas where this is likely to hit home and impact. I'm just going to take a look at the area of human resources before I then hand over to Sally to look at the other areas of financial services, life sciences, cloud, and OBA. So as far as the human resource area is concerned, we could in fact devote a whole session to this. And if the demand is there for that, please do let us know. If that's something you would like us to do, then we will consider that as part of our webinar program, given that so many organizations are data rich from a HR perspective. Just to look at a few areas where the data protection regulation is likely to hit. If you look at the concepts of personal data, it's quite clear that the concepts of personal data under the regulation is much broader than what we have at the moment. And therefore, if you ever thought there was any doubt that HR-related data was outside the scope of personal data protection, well, this is probably going to kill that doubt off for good when the new regulation comes forward. Pretty much anything relating to individuals, whether that's potential employees, past employees, etc., will all fall within the ambit of the new data protection regulation. And that's going to have to be factored in terms of the compliance controls that will need to be instituted to meet requirements around that. And that will look at issues such as consent. Consent requirements under the regulation are much tougher than what we have at the moment. There is a greater burden of proof that applies to the data controller. Consent has to be specific and explicit under the new regulation. There is much more prescriptive nature of rule sets in the regulation around how consent can ever be deemed to be valid, if at all. So much more will have to be done in terms of making sure consent within the employment context, within the HR context, is actually valid consent. And from a consent perspective alone, the regulation also states that consent is always going to be called into question in terms of the validity of consent where there is perceived to be an imbalance of power between the data controller and the data subject. And one example that's mentioned in terms of where that imbalance of power typically may arise is within the context of the employer and employee relationship. So consent is one to certainly have a look at in a bit more detail going forward. And I think the often over-reliance on consent, the approach that consent is something that you need to have into place and therefore will always build into employment contracts, etc., I think will change going forward. You will also find, again, if you want to probe into other details around data transfers and have a bit more of a look on the impact of the new regulation, the area of human resources, how it impacts on compliance, please do have a look at the Global Data Hub this month. We've published quite a few articles that will demonstrate the potential impact there. So I'm just going to hand over to Sally Ann Rowe to walk us through the next few slides.
Thanks, Vin. It's not surprising, given how data-rich the financial services sector is, that there's a fair amount in the draft regulation of significance to this sector, and concerns have been raised by both the British Banking Association and the Association for Financial Markets in Europe on aspects of the proposals. First, the regulation doesn't offer any greater clarity to that already provided in order to legitimise processing by the industry where needed to comply with the raft of regulatory rules, guidance or codes that they're already subject to. Now, these regulatory requirements often fall short of being legal obligations to which separate legitimising criteria under data protection law currently exist, but can carry significant penalties for non-compliance. At present, legitimate interest is relied upon as a lawful basis by the industry in order to process data that's necessary to comply with this regulatory regime. But the processing doesn't sit comfortably with this condition, and in the absence of any additional clarity under the proposed regulation, this could only lead to further conflicts of law and problems for businesses. Changes to subject access will also present challenges to this sector. In particular, Article 12 of the draft regulation allows people to submit electronic or email access requests for information, subject access requests. In practice, however, it's going to be hard for a bank or a financial institution, for example, to do the checks that are needed to securely verify the identity of a person who may make access requests in this way. In addition, there's going to be problems with providing information in this way, where this may require perhaps highly secure encryption tools, which may not be compatible with the applicant's or the customer's own systems. More generally, you've also got the revised time scale for responding, which is now a month in order to provide information to data subjects. This is down from the current 40 calendar days to respond, and it's going to present a real challenge in the banking sector due to the significant volumes of data that can be held. We also have the enhanced consent requirement. Now, this is going to place a heavy burden on business in this sector. Looking ahead, financial service providers will be more likely to have to distinguish consent mechanisms from other equally, if not more, important terms, and make more effort to provide standalone consent notices. Other concerns in this sector will include, for example, the level of the proposed fines in the regulation for non-compliance. There's been concern that these have been considered to be disproportionately high and that they have no statutory maximum on the amount that could potentially be fined. And also the absence of any clear carve-outs in the law that would recognise the need of the sector to process personal data for money laundering and crime prevention purposes. When we look at the life sciences sector, there are a number of issues that are particularly relevant to the trials and research that this industry conducts to develop and supply safe medicinal products. Research projects typically involve parties around the world with significant transfers of personal data. While only having to deal with one lead data protection authority under the regulation will clearly ease compliance burdens, there are going to be additional administrative obligations that will likely add increased compliance burdens on the industry despite this. In particular, you're going to have obligations to conduct privacy impact assessments where processing operations are going to present specific risks to the rights of data subjects due to their nature or scope or purposes. Given that life sciences companies may be processing health data for medical research, this may account for a significant proportion of the processing, therefore placing further obligations on them to consult with subjects and potentially regulators when running trials. Then we have consent. Consent's already relied on by the industry to justify the processing of subject data, yet consent won't provide a legal basis under the regulation, as Vin explained, where there's a significant imbalance between the position of the data controller and that of the data subject. Clinical trials could potentially fall in this definition, throwing doubt over to whether consent can continue to be relied upon as the legitimising basis for certain data processing operations. Another unique challenge for many life sciences companies is that they're legally required to process sensitive personal data in order to comply with the Pharmacovigilance Directive. Now, under this legislation, pharmaceutical companies have a strict obligation to report adverse events relating to a medical substance or a product which requires the processing of sensitive personal data. The directive provides a legal basis for processing personal data under the current data protection regime, and this will also need to be the case under the new regime. Pharmaceutical companies will need to formulate methodologies to ensure that only that data that's absolutely necessary for this legal obligation is being processed in order to avoid any conflict with their separate data protection obligations. Also relevant here is the amended definition of personal data. The regulation clarifies that personal data includes data that directly or indirectly identifies a person by reference to an identification number or one or more factors specific to that person, which might include factors such as their physical, physiological, genetic, or mental identity. In addition, there's a proposal to introduce a further concept of pseudonymous data, being data that doesn't permit a person to be identified, but allows that person to be singled out in some way. Then there's also the recognition in the regulations that it should not apply to data that is rendered anonymous, so that the subject is no longer identifiable. Now, all these competing terms are likely to involve a complex assessment by a data controller in this specific space as to whether their processing falls within the scope of the regulation and the extent of their compliance obligations that this processing then gives rise to. issues under the regulation relevant to processing in the cloud, we can see that the extension of the territorial scope of the regulation to service providers not just established in the EEA, but also those outside and offering services to individuals in the Union, will have implications for cloud service providers. Where cloud services are subject to the regulation, then providers, especially those offering software as service solutions, may find subject rights where their individuals wish to port their data to a new supplier could lead to a significant increase in their costs. In addition, we have that proposed timescale of 24 hours for reporting breaches to a relevant data protection authority. Now, this will extend to cloud service providers, given that the obligations here apply equally to data controllers and to data processors. For cloud providers using distributed architecture, this timeframe could prove too short in practice to investigate and pull together an appropriate notification to an authority. The extension of responsibilities for processors will also impact on contract negotiations with clients, as well as extend potential liabilities, not just to the company on whose behalf the processor is acting, but also potentially for damages to individuals who might be affected by the processing. There are also the transfer rules, for which the standard contract terms are currently used, in addition to binding corporate rules at present. It's worth noting here that standard contractual terms are likely to be necessary under the regulation, not just for transfers, but for all processing and sub-processing activities. Finally, we look at the implications for online behavioural advertising, where online user data may be collected into profiles, typically using cookies, to deliver advertising that's relevant to the user's interests. Now, as with the life sciences industry, the extension of the definition of personal data and the potential introduction of a concept of pseudonymous data will bring the use of tools such as cookies or IP data to deliver online behavioural advertising clearly within the scope of the regulation. This may mean that the full range of obligations relating under the regulation, including those relating to consent, will need to be considered unless there's a recognition that these rules relate to any wider definition of personal or pseudonymized data, and are distinguished from those where the data relates to identified or identifiable individuals. Otherwise, how could an online OBA provider, for example, practically comply with subject access rights, for example? The UK Information Commissioner makes clear in his recent detailed analysis of the regulation that the rules of data protection would need to be applied realistically in this area where a real-world identification cannot, in practice, occur. In particular, the regulation also provides at Article 20 a right for a person not to be the subject of automated processing intended to evaluate certain aspects relating to them or to analyse or predict factors about them. These factors include personal preferences and behaviour. The right is limited to circumstances where the processing produces legal effects or significantly affects the person. But it's considered that OBA profiling may well be processing that significantly affects a person here, although the scope does need to be clarified. It's worth noting that further amendments have actually been proposed to this article by the European lead rapporteur of the Libe committee that has been mentioned, and would, if adopted, replace this proposed right to object with a complete prohibition on profiling unless this was carried out with consent or where required by law, and again could obviously have particularly problematic implications for the OBA industry depending on the scope of the prohibition to its activities.
Thank you very much, Sally. We hope you found that run through and the update on the regulation very helpful. We've had several questions come through, and I think we do have time to look at some of those questions, which I'll do in a moment. But before we do that, as I mentioned at the outset, we do like to gauge your views as part of the polling questions. So we'd be very grateful if you could address the polling questions which have just opened on your screens right now. And there are 3 questions we'd like you to look at, please. First of all, do you think that the proposed regulation will result in DP compliance cost savings for your organisation? Yes, if you think it will result in savings, or no, if you think actually it's going to cost you to do that. The second question is, do you think that the proposed regulation will result in additional compliance burdens for your organisation? So yes, if you think it will result in a more compliance burdensome regime, or no, if you think it will become lighter for your organisation. And then finally, would your organisation need to appoint a data protection officer? And as I mentioned, this is part of the new compliance regime under the new regulation, where if you have, as currently proposed, 250 or more employees, and you're not classed as an SME, a small or medium-sized organisation, there is a need for you to appoint a data protection officer. So yes or no would be great. So please click away on that. I'll bring you the results of that in a moment. And the reason why we've posed these particular questions is that when this package, or this regulation was actually launched last year, one of the chief justifications for the regulation from the European Commission is that it will lead to administrative savings of, and I quote, 2.3 billion euros per year across the member states. That's a savings that should be made by data controllers. And that was a proposition put forward by the European Commission. The Ministry of Justice, as I mentioned a few moments ago, as I mentioned at the start of the webinar, and many other industry organisations have conducted their own cost-benefit analysis and exercises and found that their results showed something quite extremely different, in fact, pretty much the opposite. So let's just have a look at some of the responses that have come in from the polling. So in terms of, do you think the proposed regulation will result in data protection compliance cost savings? So only 5% of you think it will result in a saving. 95% of you think it will not result in a saving. And that's fairly similar to the survey question that we conducted about this time last year when these proposals were introduced in our first webinar. Second question, do you think the proposed regulation will result in additional compliance burdens? Again, not surprising, but it's very useful for us to have some form of empirical evidence around this, in that we've actually questioned the many participants and the broad spectrum of participants we have today. 95% of you think it will result in an increase in the compliance burdens. Again, not surprising, but again, it's good to have that view from the polling today. The third question is around the compliance-driven requirement for a data protection officer. And almost 60% of you think that you will need to have one under the new regime. Again, a huge sea change in terms of where you are now to where you will need to be in terms of the data protection officer requirement under the proposed regulation. So thank you very much for polling on that. Just before we finish up, there's some questions that are coming, and I'll try and take a couple of them now if I can in the final few minutes. One question that's come in is around the use of data loss prevention software, which is essentially software which is designed to increase, in some respects, monitoring potentially of employees and how employees safeguard personal data that they are entrusted with as part of their daily operations, and whether or not the introduction of data loss prevention software will result in regulatory approvals requiring needing to be obtained first. Under the current regime, there are several member states in Europe that will require at least a form of local filing in relation to the use of DLP software. And in many cases, that filing is beyond just an administrative step. It is something that will require approval, predominantly because of the monitoring nature of DLP software. And some member states attract a greater degree of protection around the use of monitoring software, or just the use of monitoring per se within the employment context. So at the moment, yes, you will need to seek approval in certain member states across Europe. So if you're trying to roll this out pan-European, you will have some approval requirements in certain member states. Under the proposed regulation, that should change. I say should because the regulation envisages an environment where local notifications and localized administrative steps ought to disappear across this new harmonized environment. Some national regulatory authorities have suggested that they may not repeal some of their current administrative requirements unless it actually conflicts with what appears in the regulation. So there is still a question mark, which is why I use the word should. There is still a question mark around whether or not the filing and the authorization requirements in all contexts will disappear under the regulation. We hope it does, because that ought to fit into the concept of harmonization under the proposed regulation. If those concepts of harmonization genuinely live through and translate into from theory into practice, then pan-European business, pan-European processing of data should become easier, and that doesn't mean that there are no requirements that will apply in this particular context. You will still have to face your own compliance obligations with your home authority. That will scrutinise what you're trying to do with the data, so you'll have to approach them. I mentioned compliance requirements. Privacy impact assessments, privacy by design, will be crucial, and in many cases will be a fundamental requirement, in other words, mandatory, in order for you to have a viable rollout of a pan-European product, particularly if it's something like DLP software. Very quickly, I'm just going to take a final question, which is around whether an organisation should actually be doing something now to comply with the proposed regulation. What you would have probably geared from the impact assessment and the impact that we've explored today is that there are some fundamental changes, and many organisations, I think, will need to consider, and what they should start to do now is to consider how it will impact on your organisation. And that's where clients are currently instructing us and currently coming to us to say to us at Taylor Wessing, how is this likely to play out for our organisation, and what should we start to think about right now? And some of those concepts around right to be forgotten, data portability, are areas that you can start to think about right now. Some of our clients are saying to us, we're beginning to look at our 3 to 5 year plans around technology build, around what sort of software requirements we will have in the next 3 to 5 years. What should we do from a strategic perspective to take into account what the proposed regulation may bring? And again, issues such as data portability, where technology solutions will be required, ought to be built into those particular plans. So also bear in mind that it is proposed that the regulation will come with a 2-year sunrise period. So there will be time to gear up and make yourself compliant. As with anything else, we would say don't wait until month 23 before you start that process. Do take full advantage of the 2 years. Many organisations will need the 2-year time gap to actually implement what's being proposed under the regulation. Thank you very much for joining us today. We will hopefully see you at our next webinar, which will be on Tuesday the 16th of April. And the next topic we will be looking at will be bring your own device, and the broader concepts and issues around data protection and the mobile workforce. We hope that's going to be of interest to you, and you'll join us at the next webinar. Just to remind you, much of what we've discussed today in the webinar is available on the Global Data Hub. The slides and the recording of the webinar will also be available in the next couple of days. On the team here at Taylor Wessing, thank you very much for joining us today, and we look forward to seeing you soon.